Some of the most difficult divorce cases in Colorado, in the United States, are cases in which there's been domestic violence by one party on the other, or even between the parties. And this can have some effect on the divorce in Colorado. Regarding assets and debts and the division of the marital estate, the effect is usually small. Because Colorado is a no-fault state, unless that violence has been financial abuse, has been wasting of assets, and that kind of thing, it doesn't have a huge effect. Where it can have substantial effect in a Colorado divorce, usually if there's been substantial domestic violence, mediation will be waived because the court is not going to insist on these parties having to try to work things out. Putting a victim in a position with an abuser is not seen as an effective way of resolving the things that need to be resolved in the divorce. And in the allocation of parenting responsibilities, parenting time, decision-making in particular, the domestic violence can have substantial effect. For instance, in a case where there's been domestic violence, the presumption or the predilection to ask the parties to make parenting decisions going forward together, collaboratively, shared decision-making is gone. Presuming in this discussion that the violence was not perpetrated in front of or against the children, it may not affect parenting time. If the children were not affected by it and the children still have a close relationship with both the committer of the violence and the victim of the violence, the parenting time might still be equitable between the parties. But the court will definitely take a look at whether that means that decision-making should be shared. So that's another way that the violence would have a major effect on how the case is decided and how the case is adjudicated. In Colorado, there are protection orders that are available for parties that are victims of domestic violence. Inside of a divorce, and sometimes civilly, there can also be protection orders regarding domestic violence. And these can be orders that prevent the abuser, from the person who's committed the violence, from having contact with the victim, from being anywhere near the victim, from contacting the victim electronically or through the mails or through third parties. There are lots of rules that can be put in place to protect the victim from the committer of the domestic violence. And in a divorce case, these things can be temporary and they can be made permanent. And this, of course, affects everything, right? Because if there is a no contact, if there is a prevention from being physically near the victim, this complicates, of course, the exchange of parenting time. This complicates communication regarding parenting. It's, if there's no children, the effects are really minimized. But when there's children, it'll affect all these different things. And the perpetrator of the domestic violence, the person against whom the protective order is issued, will have to abide by these restrictions. And so will, quite honestly, the victim. So you want to be sure on both sides that the rules are followed to protect really both parties, but really to protect the victim mostly. That is, how the protective order, lives on and past the divorce. A lot of people have questions about prenups. Well, it's funny, in Colorado, which calls many things different than other states, prenup is among them. So in Colorado, we call them premarital agreements. And a premarital agreement is kind of what it sounds like. It's an agreement made before the marriage is completed as to how the assets and debts will be divided should the marriage dissolve. It can also, and a lot of people don't realize this, it can also define how the parties will behave as to their assets and debts and other things during the course of the marriage. Some of those other things can be more or less enforceable, but I've seen premarital agreements that involve who will do the dishes on what night, What a premarital agreement does, though, is it causes the parties to actually take a very mature step towards their married life, to take stock and assess the resources with which they're coming into the marriage and what they expect to develop during the marriage and how they intend to treat one another regarding those resources, regarding those assets, regarding their debts during the marriage and after the marriage, should that ever come to pass. It involves, in Colorado particularly, a complete disclosure of the financial circumstances of both parties, because it is not favored for someone to be entered into a premarital agreement unless they understand what they're giving up and what they're getting. And so that disclosure requirement is something that is probably healthy and probably should be done by more people prior to getting married, to understand the full asset and debt picture of their partner for life prior to entering into that partnership. In business, we'd call it due diligence, and I don't want to make it less romantic. But quite honestly, it's about vulnerability. It's about sharing. It's about openness. It's about entering the most intimate relationship that you're going to ever have without hiding things from your soon-to-be partner. And so a premarital agreement, even if it doesn't really protect much or have much effect today, can be an important and mature way to start this journey of partnership together in a way that is defined and fair to both parties. And this is probably the most powerful aspect of a premarital or prenup agreement. Many of our clients come to us with complex marital estates, assets that have tax consequences, business assets, residential assets, vacation homes, retirement accounts, debts, both to the taxing authorities and other debts, and come to us in that wondering how the divorce, if they go through with it, will affect the tax consequences of all these things. While we certainly work with our clients to help them with the answers to those questions, we almost always will also associate with their tax attorney or a tax attorney that we recommend. And the reason for that is that not only are we not tax attorneys, but the court is not a tax court. And even the judge, or if we're working with a mediator or an arbitrator or the judge of the case, none of them typically are experts in tax and are not always aware of how the decisions they make will affect the tax circumstance of both parties, of either party. And it is up to the lawyers, it's up to you, to advise the court of what those tax consequences are going to be, because these are not tax courts. So that is why when tax implications, tax changes in the parties' tax circumstances are important, that we involve a party or parties in the case. We involve them as experts in the case to advise us, to advise you, and advise the court as to the tax consequences, so that the results that we arrive at in the case, whether they're agreed results or a result of after trial, can be fair to the parties, with everybody understanding all the consequences of the decisions that are made.